Okay, we've talked about priority and the benefits of registering on the principal register. Now let's talk about how you go about actually doing that. What we're going to be looking at are basically the forms and procedures you need to go through in order to file a trademark application. Now, you've probably seen next to some people's trademarks a little TM. What that means is that they don't have a federally registered trademark. Once you get a federally registered trademark, you get the added pleasure of being able to have an R with a circle around it after your trademark. And while 90% of the population won't know what that means, it will give you a warm feeling in your heart to know that your mark is protected. So let's talk about the overall process first. The first thing you have to do to get a federal trademark is to file an application. We're going to focus on two different grounds for filing an application. The first ground is past use, meaning I've used the trademark before, I've used it in commerce, and so I can file this trademark application. The second basis would be intent to use, which basically means I haven't used the trademark yet, but I'm going to, and I want to reserve it so that I can use it in the future. So you have to choose one of those two bases. There's also, there's actually 4 grounds for filing a trademark application. The other 2 are if you filed for a foreign trademark or you already have a foreign registered trademark. So you send in your application, and we'll get to the application details in a minute. What happens is your application goes to the USPTO, and an examining attorney is assigned to look at it. And she will look at it, and she'll run some searches of her own to decide whether your trademark application is adequate and whether the trademark should be registered. Usually what happens is if they don't immediately approve it, they send you what's called an office action, which is basically a letter, or actually now it's an email, that you get that says, hey, you know what? I know you want to register this trademark, but there's some problems. It's descriptive, or you haven't provided enough evidence of this, or there's a conflicting mark, or something. And so you communicate back and forth with the examining attorney until you convince her, she convinces you, or you make some adjustments and she compromises until it can move to the next step. However, if you're unable to get there, if you reach an impasse and the examining attorney is done working with you, then they'll file what's called a final refusal, which is something you're going to have to, if you want to appeal that, you have to take it to the Trademark Trial and Appeal Board. Okay, the next thing that happens is, so the examining attorney has given her blessing of your trademark application. Now it goes public, and what they do is they publish your mark in the official Gazette for 30 days. Who looks at the official Gazette? Well, pretty much only lawyers who are looking to see what trademarks other people are trying to get. If it sits on the official Gazette for 30 days and nobody files an opposition, then you're golden. But you gotta wait the 30 days. So there's a 30-day wait. Any affected party can file an opposition. If the opposition is filed, it goes to the Trademark Trial and Appeal Board to decide whether the trademark should be registered. So let's assume that things go well, nobody opposes it. The next thing that happens is, well, you're done in some cases. If you've applied for a registration based on past use, you will get a certificate of registration, which you can frame or put under your pillow or do whatever you like with. If you filed an ITU, then what you'll receive is a notice of allowance, meaning, okay, we approve this, but you haven't used it in commerce yet, so you still have to, within the time limit, prove that you've used the mark in commerce. And then finally, after you've gotten your trademark, you've got to maintain it. To keep the trademark live, you occasionally are going to have to file documents saying that you're still using the trademark and that, well, basically that you're still using the trademark on the same type of goods as you registered. Now, as I've said, there's some opportunities to appeal to the Trademark Trial and Appeal Board if you get a final refusal, if an opposition is filed, or if somebody, after you get your trademark, objects to it, they can file a request for cancellation. This is good to know also if you're not trying to register the trademark but trying to prevent it from happening. There are these 3 different occasions where you can catch a trademark and try to undo it without going to federal court. Instead, you just go to the Trademark Trial and Appeal Board. Okay, so we've talked about the overall process. Now let's zero in on the trademark application. What do you need in order to register the mark on the principal register? Well, the first thing you need is you need a trademark that is distinctive. And as I hope you already know, there are 2 ways of being distinctive. There are marks that are inherently distinctive, and there are marks that become distinctive by obtaining secondary meaning. It has to be one of those. If it's a mark that is not distinctive and hasn't obtained secondary meaning yet, you cannot register on the principal register. So if it's some kind of made-up name, then most likely it's going to be inherently distinctive. If, however, it's Brigham's Ice Cream Store or some descriptive trademark, you're going to have evidence that it has obtained secondary meaning before you're going to be able to put it on the principal register. Okay, second, you need to verify that somebody else doesn't already own the trademark and that you're not trying to register something that's generic or descriptive, and you have to disclaim those parts of it that are generic or descriptive. Third, you have to say how you're going to use the trademark. What classes of goods and services are you going to use the trademark on? If you're filing a registration based on past use, you can only register for products and services where you've actually used the trademark in commerce. If you're filing an ITU, you can only include products and services that you will be providing in commerce. So if I am selling baseball hats under a trademark, then I can, and I've sold some already under my trademark, I can register for the category of baseball hat sales. If I were to register for baseball hat sales and t-shirts, then I would be overreaching because I haven't sold any t-shirts yet. So maybe I could file a Section 1A application based on past use in selling baseball hats and an intent to use it on t-shirts as well. But you need to be careful here, and clients very often want you to claim everything under the sun and then some in your trademark application, so they'll have really broad protection. The problem with that is if you claim to have used it on products and services where you never actually used it, then the whole trademark can be invalidated for fraud and you can get in trouble. So you want to be careful here. And with the ITU, you want to be careful that it's actually going to be something that your client will be providing in commerce rather than something they hope to provide someday. You need to make sure it's when they file the certificate of use that they're able to say, yes, and we sold this particular product in commerce. Finally, you have to show some kind of use that supports the application. And you have 4 choices. First, you can file an application based on past use. As I've said, so you would say, I've been using this trademark for baseball hats for this length of time, and I've used it across state lines, therefore please give me a trademark. You can also do it based on intent to use, and that's pretty easy. All you have to do is verify that you have a bona fide intention to use the mark. Okay, I've found this trademark, I'm starting my company, this is what I really want to do, or this is what my client wants to do. And then, as I mentioned, you can also file based on a concurrently filed application for a trademark in a foreign jurisdiction, or an already registered trademark in a foreign jurisdiction. Okay, so before you go to the USPTO website, you got to make some decisions. First, what kind of use supports your application? Are you filing based on intent to use, or are you filing based on past use? And this is a pretty easy decision. I mean, if you've used the mark in commerce already, you're filing based on past use. If you haven't used the mark, then you're filing an intent to use. And you can actually split it up. So if you've used the mark on products X, Y, and Z in commerce, then you can file a past use registration based on those products. And then if you're intending to use it on 5 other products, you can file an intent to use on those 5 other product categories. So, do I want my trademark to include colors and logos? Clients sometimes think that it's going to be better for them if they put a pretty logo or a rainbow or a skull or something fancy on their trademark. I mean, that's what, when you think of a trademark, you think of logos and cool stuff like that. So that's something you need to decide because you need to register it. I'm going to suggest in a few minutes that it's better to not add all of that stuff in your trademark application, because I think it gives you greater freedom to add that stuff at later times. Third, do I need to provide evidence of secondary meaning or any explanations? So if you're filing a registration for a descriptive mark, you'll remember descriptive marks are not inherently distinctive. So that means you've got to prove that it's obtained secondary meaning. You also might, if you found, whether it's descriptive or not, if you found another trademark out there that's somewhat similar to yours, and you want to explain to the examining attorney why you believe that yours is distinct, you can include that there as well. And then finally, which classes of goods and services do you want to identify for use of the mark? Okay, now's the fun part. So, you go to the USPTO website, which is uspto.gov, and you click where it says File Forms Online. Then you go down and you see where it says Initial Application Form, and click on that. And then, since we're talking about registering on the principal register, you'd click on number 1. So this is the screen that comes up, and you have the choice of using the TEAS Plus form or the TEAS form. The only difference is, or I guess the major difference is, that the TEAS form that doesn't have the plus, you get to write your own description of the product or service. Usually that's not going to be an issue because whatever product or service your client is offering has been offered before, and so it's in there already. But if it's a totally new thing, you might need to use a TEAS form, which costs a little bit more. So you click on that, and you scroll on down. This tells you what you're going to need to do. Read that, but I won't read it to you. And then down here you click on, is an attorney filing this application? I know you're not attorneys yet, but click yes anyway, and then click continue. You'll notice here if you can actually save your application to your drive if you get interrupted halfway through. Okay, so this is the next screen that comes up. Basically here you identify your client. So what's your client's name? What type of entity are they? Where are they? What's their address? Things like that. You can mostly make this stuff up. I mean, not in real practice, but for this exercise you can. Next, they get right to the point and they say, okay, what do you want to register? what's the trademark? And so if you go down, you'll see in bold it says click the appropriate circle to indicate the mark type. And we've got standard characters and we've got specialized form. So, do you want your trademark to include colors and logos? Standard character marks one that's just a word, like Coke. A special form means that it's anything other than just a word. It has font or color or sound or design or something that is being registered along with the name. Well, how do you decide what to do? Let me give you some food for thought, or some drink for thought, actually. Let's say you register this, the Coca-Cola logo, and assume that Coca-Cola didn't already do it. You could prevent other people from using that. However, if you were to register this, the Coca-Cola words, you could prevent others from using any of these versions of the word Coca-Cola, no matter whether they're red or blue or green or yellow, whether it's on a black background or a white background or a red background, or just written out. So you get much broader protection if you use word marks, standard character marks, I should say. So why on earth would anybody do a stylized trademark? Well, the answer is when somebody else already has a trademark that's similar to yours, you can sometimes distinguish yourself and get on the principal register by adding some color or something different. It's going to narrow the scope of your trademark rights, but it's going to help you distinguish yourself from another trademark. So it's really a judgment call based on the market out there, what other people have, how similar your trademark is, whether you want to try and get it for a standard character mark or whether you want to stylize it. What a lot of people do is they start with the standard character, and if they get an office action on that, then they consider whether they want to stylize. Okay, so let's say you take my advice and you decide, okay, I'm going to use the standard characters. What you would do is type in to that box your trademark. So here it's some electric glow pants, which I'll call fancy pants. I'm sure you've seen that type. If you're using a specialized form, then you'll need to click where it says specialized form, and something will pop up beneath there for you to fill out. Here you can upload a JPEG, basically an image of your trademark with all the skulls and whatever else it is that you, circles and lines and logos that you want with your trademark. Then you need to describe what is in the mark in a number of ways. You need to say the literal element, meaning the words. If there's colors there, you got to describe the colors. So, attach your image, identify the words, identify the colors, and then describe the mark generally. So, back here though, back where we're clicking on standard characters, you don't have to do that. In either case, the next thing you would want to do before you click continue is you see that little unchecked check mark where it says check here if you need to enter an additional statement. You'll want to click that if you're filing a descriptive trademark, and so that you can provide evidence of secondary meaning, or if there's some other reason or something you want to explain to the examining attorney. Like, hey, I know somebody else is using a really similar trademark, but mine is different because, or there's not going to be confusion because. You click there if you want to enter that information. So here is the place for additional statements. Usually if you have something like Inc. or LLC or some term that's part of your trademark that is generic, you want to disclaim it here. Otherwise, you'll get a rejection and you'll have to go through the trouble of sending back saying, okay, we disclaim that. There's some other places here. If you're using a word that means something in another language or in a certain trade, you need to say what that means in that language or trade. It goes on. If you're filing an application based on past use and it is a descriptive mark, as we've said, you need to provide evidence that it has obtained secondary meaning. And that's what we call Section 2F evidence. So, what you need to do is click there and upload evidence showing that your mark has acquired secondary meaning. Basically, evidence that you've advertised broadly, that maybe a poll taken where people recognize your mark. Some kind of evidence to show that whereas your mark is descriptive, it has obtained secondary meaning, so it's okay to be registered on the principal register. And then down below there's the spot to put in miscellaneous statements. If you want to make any disclaimers or explain why you think that the mark is valid even though somebody else has a similar mark. And I tend to think it's a good idea to explain things in advance, because if the examining attorney doesn't catch it, like let's say somebody else has a similar trademark and the examining attorney doesn't catch that other similar trademark, at the end of the form you're going to be signing your name to say that everything here is true and correct, and that to the best of your knowledge there's nobody else who has a right to the mark. I would be nervous to sign my name if I knew about something that I didn't reveal here. So enter your stuff and then scroll on down and click on continue. Okay, next you have to decide which classes of goods or services you want to identify to use your trademark with. So where you click is where it says add goods/services by searching ID manual. Click there. Okay, and you get this lovely search form where they say requests can be for a single item, e.g. pants, or multiple items. So type in what product or service you're going to want to use your trademark with. I searched pants for my fancy pants. Okay, so what you'll see is a bunch of, well, depending on the product and service that you choose, you might see a bunch or only a few. But for pants, you can see it goes on and on and on. You'll notice on the far left that there's different international classes. You will pay based on the number of international classes you register. So let's say I register apparel for dances, athletic apparel, balloon pants, camouflage pants, and capri pants. All of those have the same international class, 025. So I'm going to pay the same amount, just one flat fee for all of those. If, however, I were to file for, if I were to claim disposable training pants, pant hangers with articulated spring clamps, moisture-absorbent microfiber texture, and each one in a different class, then you're going to pay quite a bit more because you pay by the class. Once again, if you want to choose the most general product or service you can, as long as you're not overreaching. So be sure not to choose something that has things in it that you don't do. Like if you're just selling electric pants, don't choose general pants. If you're selling athletic pants, don't click on the athletic apparel, just click on athletic pants. So you don't want to overreach. so you'll check a description. Now, as I mentioned, if you're filing based on past use, you can only identify things where you've already provided already sold the work in commerce. If you're filing an intent to use, that's for things that you're going to be selling or providing in commerce. And you can mix and match. You can file partially based on past use. In the past, I've used this on athletic apparel, and in the future, I plan to use it on baby clothes. That'd be kind of weird, but you could do it. Okay, so for each class that you choose, and for this exercise, I'd recommend only choosing one, but you can choose more than one if you like. For each class that you choose, you need to enter the basis for filing. You're either filing based on past use or based on intent to use. And again, if you've used it before, if you already used the trademark in commerce, meaning across state lines, you click on 1A. If you haven't used it yet, you click on 1B. If you click on 1B, you'll go on to the next step. If you click on 1A, you'll need to put some evidences showing how you use the trademark. So now notice this is not evidence of secondary meaning. This is evidence just to show what your trademark looks like. It's the specimen. And I don't mean that in the doctor sense of specimen. I mean it's the piece of evidence that shows, hey, this is what it looks like when I send it to across state lines. So if you're selling baseball hats, you take a picture of the baseball hat with the brand on it and you upload that. And then you need to say when you first used the mark anywhere, and then when you first used the mark in commerce, meaning across state lines or in such a way that affects interstate commerce. So next what you would click is, don't click exit, click assign filing basis. Alright, so you'll look now, dress pants has been assigned a filing basis as 1A. If you had clicked on section 1B, then it would be assigned based on 1B. Now let's continue on. Okay, so here, fill this form out as though you were the attorney representing the client who's trying to get this trademark. Okay, this screen will come up next. It'll show you how many classes of goods you are registering, show you the price per class, and total everything up. And then you need to sign it, basically saying, hey, I'm not being fraudulent. And the easiest way to sign it is to click Sign Directly. Scroll on down, and where it says Signature, you put / your name, then a backslash. Where it says Signatory's name, you put your name without the backslashes. Signatory's position, you'd put Attorney of Record, and the date signed. But before you do all that, take a look at Declaration. And look at what you're agreeing to, because you do not want to be signing your names to things that are going to get you disbarred or otherwise get you in trouble or get your client's trademark invalidated. So it's saying you have to affirm that you, where am I? You declare that you're authorized to execute the form, that you believe the applicant's the owner of the trademark, that he's entitled to use it, that it's not causing confusion with anyone else, that you haven't made any material misrepresentations, that everything is said to your best knowledge is true, all of that stuff. Okay, and then you click Validate. And what it will do is look over, make sure you didn't skip anything. If there's, make sure there's no no spaces that need to be filled in. Okay, next this comes up. Now, I don't want you to actually file a trademark registration because the trademark office would get kind of mad at me if a bunch of my students were filing trademark applications and not paying for them and not actually wanting to get the trademarks and using fictitious clients. I think they wouldn't like that. So I'm going to ask you not to actually submit your trademark application to the USPTO. Instead, what you can do is go over here on the left where it says Input and click on that. That will give you basically a summary of your answers to the forum questions. If you go down to the bottom of that, there's a place where it says View/Save as PDF. Click on that, save it as a PDF, and save it on your hard drive so that you can turn it into me at the end of this intersession. If that doesn't work, I know sometimes Macs have trouble with that input PDF function. You can go over to the text form and you can print that out instead. But try the input first because that gives you a much better looking result. It's easier to read. Okay, and there you have it. You have now successfully filed a trademark application. We didn't file it, but you completed one. And now you can go back and do it again and eventually do it for real life clients for real life money.